again crave your indulgence as I rise to have the bill shortly entitled the Eastern Caribbean Supreme Court Judicial Officers Pensions Bill 2021 read a second time. Mr. Speaker, this bill seeks to provide for the payment of pensions and gratuities in respect of the service of judicial officers of the Eastern Caribbean Supreme Court. Mr. Speaker, as you would know, the Eastern Caribbean Supreme Court, along with the Parliament and the Executive, is the third critical component of our form of government and governance, and it is incumbent on me to give a brief overview and some history of our court. Mr. Speaker, it would have been in 1967 that the Organization of Eastern Caribbean States, namely Antigua and Barbuda, Dominica, Grenada, St. Vincent, St. Kitts, Nevis, and Anguilla, and St. Lucia, would have joined in a new status of association with the United Kingdom in accordance with the West Indies Act of 1967. The Act provided for Her Majesty, by order in Council, to establish common courts for the associated states with, and I quote, such jurisdiction and powers as may be specified or determined. The order in Council also allowed provisions to be made for the establishment in common of a commission to appoint judges and officers of the court for the remuneration, allowances, and pension rights of the commission, as well as the judges and officers of the court, and for defraying the expenses of the commission and the courts. The West Indies Associated States Supreme Court order duly followed and gave effect to Section 6 of the West Indies Act, permitting the establishment of common courts for the associated states. It was termed the West Indies Associated States Supreme Court. Since then, this order has been given constitutional recognition and effect by two successive constitutions: the Associated State Constitution of 1967 and the independence constitutions of the respective states, begin with the Independence Constitution of Grenada in 1974. The most important change initiated by the Supreme Court order was the fusion of the High Court and the Court of Appeal into one Supreme Court, and the confinement of all appeals to the Court of Appeal. The previous duality, which allowed the appellate jurisdiction to be shared by different appeal courts, was abolished. This new arrangement helped to facilitate greater supervisory jurisdiction over the legal system of the individual states by the Supreme Court. It was, however, left to the constitutions of the individual states and the local legislatures to enact statutory provisions to give flesh to the Supreme Court order of 1967. The civil jurisdiction of the former Supreme Court of the Windward and Leeward Islands was vested in the High Court of the now established West Indies Associated States Supreme Court, which has in time been changed to Eastern Caribbean Supreme Court. And Mr. Speaker, that explanation and some of what I say further can be gleaned from the website that has been established by the Eastern Caribbean Supreme Court for those who wish to delve further into the background of the Eastern Caribbean Supreme Court. Mr. Speaker, the structure of the court consists of two divisions, a Court of Appeal and a High Court of Justice. The Court of Appeal, until we were faced with the pandemic COVID-19 last year, the structure of the Court of Appeal is itinerant and traveling to each member state and territory where it sits at various specified dates during the year to hear appeals from the decisions of the High Court and magistrates' courts in member states in both civil and criminal matters. The Court of Appeal hears appeals from all subordinate courts, that is High Courts, magistrates' courts, and the Industrial Court in Antigua and Barbuda. Appeals from the magistrates' court might be heard from any judgment, decree, sentence, or order of a magistrate in all proceedings. In respect of the High Court, the Court of Appeal has jurisdiction to hear and determine any matter arising in any civil proceedings upon a case stated or upon a question of law reserved by the High Court or by a judge. This is, however, subject to any power conferred in that behalf by a law in operation in that state. And subject to certain exceptions, the Court of Appeal is empowered to hear and determine the appeal from any judgment or order of the High Court in all proceedings, all civil proceedings. For the purposes of determining any issues incidental to an appeal and the remedies, execution, and enforcement of any judgment or order made thereto, the Court of Appeal is endowed with all the powers, authority, and jurisdiction of the High Court. Mr. Speaker, each member state has its own court office, which, in addition to the High Court registry, houses the office of the local High Court judge or judges, as the case may be. Filing in the registries commences the proceedings in matters before the High Court in each of the 9 territories and the Court of Appeal. The trial courts sit throughout the year. Criminal assizes, depending on the jurisdiction, may occur on specified dates in assizes. And just for full disclosure or completion, I should mention that the Eastern Caribbean Supreme Court to date comprises of the 6 independent nations in the Eastern Caribbean, in the OECS, starting with Grenada in the south, St. Vincent and Grenadines, St. Lucia, Dominica, Antigua and Barbuda, and St. Kitts and Nevis, as well as the 3 overseas territories of the United Kingdom, and we're talking about the British Virgin Islands, Anguilla, and Montserrat. The Eastern Caribbean Supreme Court to date is composed of the Chief Justice, who is the head of the judiciary, 5 justices of appeal, High Court judges, and High Court masters, who are primarily responsible for procedural and interlocutory matters, that is, the masters. The Court of Appeal judges are based at the court's headquarters in Castries and Lucia, where administrative and legal support is provided under the supervision of the court administrator and the chief registrar, respectively. The High Court judges are each assigned to and reside in the various member states. The High Court Registry is headed by a legally trained registrar who coordinates the provision of the necessary administrative and legal support for the functioning of the High Court. Mr. Speaker, judges' pensions are presently provided for under National Pensions Acts of the state to which the judge is assigned for purposes of pension. And you would find that there is an Eastern Caribbean Supreme Court Rates of Pension Judges Act 1989 as it is here in St. Kitts and Nevis. The interpretation of the judges' pension provisions has been provided in the Court of Appeal judgment in the matter of the Attorney General's reference Constitutional Questions Act, and that is Cap 17.1a of the revised laws of St. Lucia, and also in the Privy Council decision in Barrow versus Attorney General of St. Lucia, and that was a Privy Council appeal of 2015, which is now binding authority as it relates to the advice given in the AG's reference. There are a number of challenges, Mr. Speaker, with the present pension provisions that exist in the Eastern Caribbean Supreme Court. The National Pensions Acts and the Rates of Pensions Act are not the same. Judges may retire before attaining a prescribed retirement age. There is difficulty currently posed with recruitment, since persons who may be interested in serving may not do so because of the present pension arrangements. A judge joining the bench and attaining the mandatory retirement age without having served 10 years has to demit office without any pension or gratuity at all. So if you have been a judge and you can sit for 8 years or 9 years and you reach 62 and you have to retire at age 62, you're not entitled to a pension on the current arrangement according to the current act as we see it. There is no built-in adjustment to pensions for the judges who have retired. So if there are changes in terms of pensions over time, you're stuck where you are. And what we are doing here today, Mr. Speaker, is to make a first step in our jurisdiction to move to correct that situation. And I would say that in an effort to address the difficulties being encountered with the judges' pension legislation in the Eastern Caribbean Supreme Court area, the Supreme Court, the ESC, SC, would have approached Impact Justice for assistance in drafting new pension legislation across the jurisdictions. I should say that Impact Justice stands for Improved Access to Justice in the Caribbean. And this is an 8-year-old regional civil society justice sector reform project funded by the Government of Canada. It is being implemented from within the Caribbean Law Institute Center, the Faculty of Law, and the University of the West Indies at the Cable campus since the year 2014. Mr. Speaker, the new pensions bill was drafted by a consultant engaged by Impact Justice. And we must note that we may well have to see how this can work in member states, that they can be harmonized. The results of this consultancy, Mr. Speaker, that was done by the consultant hired by Impact Justice, created explanatory notes for the new Eastern Caribbean Supreme Court Judicial Officers Pensions Bill. We note that it is a three-part bill providing for pensions and gratuities for judges in the Eastern Caribbean Supreme Court, and that they would have drafted as well Eastern Caribbean Supreme Court Judicial Officers Pensions regulations. And if I may, Mr. Speaker, just briefly highlight what are some of the highlights of this new pension bill. Provision is made for an early retirement age if this is ever incorporated in the Supreme Court order. Provision for master to be paid a pension under the new bill. The post of master is relatively new, and as I mentioned earlier, deals primarily with preliminary and interlocutory matters, but they have never been brought under the question of pensions. Pensionable emoluments to include a salary as well as housing and utilities allowance. Pension may be granted on reaching the retirement age on or after serving at least 5 continuous years of service. And that is so before reaching the normal 10-year retirement age as before. Provision of a prorated pension where a judge has served more than 5 years but less than the required number of years for a full pension. There is an increase in the spouse's pension from 50% to 2/3 where the judge predeceases their spouse. Provision for the payment of pension where a judge has served the number of years to qualify for full pension but demits office before attaining the retirement age. Provision for increases in pension in line with increases to the pensionable emoluments attached to the office of a judicial officer. We have gratuities where a judicial officer's length of service does not qualify for pension. That is less than 5 years. Gratuities where a person dies while holding office as a judicial officer, but at the date of death is not eligible for pension or a gratuity. Mr. Speaker, if I was to turn to the actual bill before this House, the preliminary provisions are set out in clauses 1 to 4 of the bill. Clause 1 of the bill speaks to the short title and commencement of the bill, and clause 2 provides for the interpretation of certain terms used in the bill. According to clause 3, the bill applies to judicial officers, and these are listed as the Chief Justice, a Justice of Appeal, a High Court Judge, or a Master of the Eastern Caribbean Supreme Court, who are assigned by the Chief Justice to St. Kitts and Nevis for pension purposes. Mr. Speaker, the administrative process for the payment of the pension of a judicial officer would begin when a newly appointed judicial officer identifies a member state or territory where they wish to be assigned for purposes of pension. This proposal would be reviewed by the Honorable Chief Justice, who before making a final determination would undertake an assessment of the number of judicial officers already assigned to the proposed member state or territory as compared to the other member states. Once this information is reviewed and the Honorable Chief Justice determines the most appropriate assignment for the judicial officer, then the decision would be communicated to the judicial officer and to the selected member state. This administrative mechanism, Mr. Speaker, would seek to ensure that all member states and territories equally share in honoring this important responsibility toward our judicial officers. On that note, Mr. Speaker, according to Clause 4, the bill is binding on the Crown. Part 1 of the bill makes provision for the pensions and gratuities payable in respect of serving judicial officers of the court. Clause 5 of the bill provides that all pensions and gratuities payable under the bill would be charged on and paid out of the consolidated fund. According to Clause 6 of the bill, the circumstance in which a pension may be granted to a judicial officer includes a minimum of 5 years of continuous service as a judicial officer. Additionally, the new rates for full and prorated pensions for judicial officers are set out in Clause 8 of the bill. Under Clause 8, the pension payable to a judicial officer on his or her retirement in pensionable circumstances in the case of the Chief Justice, if he or she has had continuous service as a judicial officer for a period of not less than 10 years, the pension is equal to the annual pensionable emoluments attached to the office of the Chief Justice, or if he or she has had continuous service as a judicial officer for a period of less than 10 years, but not less than 5 years, the pension is computed on a prorated basis. Mr. Speaker, in the case of a Justice of Appeal, if he or she has had continuous service as a judicial officer for a period of not less than 12 years, the pension is equal to the annual pensionable emoluments attached to the office of Justice of Appeal, or if he or she has had continuous service as a judicial officer for a period of less than 12 years, but not less than 5 years, the pension is computed on a prorated basis. And in the case of a High Court judge, if he or she has had continuous service as a judicial officer for a period of not less than 15 years, the pension is equal to the annual pensionable emoluments attached to the office of High Court judge. And if he or she has had continuous service as a judicial officer for a period of less than 15 years, but not less than 5 years, the pension is computed on a prorated basis. And in the case of a master, if he or she has continuous service as a master for a period of not less than 15 years, the pension is equal to the annual pensionable emoluments attached to the office of master. And if he or she has had continuous service as a master for a period of less than 15 years, but not less than 5 years, the pension is computed on a prorated basis. In accordance with Clause 9 of the bill, Mr. Speaker, a judicial officer may receive a reduced pension. The payment of a pension to the spouse of a judicial officer and the payment of pension generally are provided for in clauses 10 and 11 of the bill. Clause 12 of the bill provides for increases in pension. A gratuity in lieu of a pension is provided for in Clause 13 of the bill. Clause 14 of the bill provides for the payment of a pension or gratuity on the death of a judicial officer, and Clause 15 of the bill prohibits a pension or gratuity from being assignable or transferable. Mr. Speaker, Clause 16 of the bill provides for the making of regulations. Under Clause 17 of the bill, the Eastern Caribbean Supreme Court Rates of Pension Justice Act, this of course is 1989, would be repealed. The Eastern Caribbean Supreme Court Rates of Pension Justice Act and the Pensionable Officers Order made under the Pensions Act will continue to apply to a person who was a judicial officer immediately before the coming into operation of this bill and who chooses not to be paid a pension under this bill. And so, Mr. Speaker, I would want to ask members of this House to support the passage of this bill. This new bill seeks to provide a single, seamless code for determining entitlement and computation of pension for judicial officers, while also building equity and fairness into the process, which would enhance the attractiveness for recruiting suitable persons to the bench, and even at a later age than is the current position, which detracts from persons who may wish to serve at a later age from being interested in doing so. And once again, Mr. Speaker, I would wish this bill safe passage. May it please you, Mr. Speaker.